Tip FM's Tip Today.
With Slattery's Garage, Puck On. Over half a century driving the people of Tipperary and surrounding areas with quality, reliable and economical vehicles, new and used. Call the sales team today to discuss your next car or van on 067 24111.
Thanks, Paul, and welcome back to the final hour of Tip Today. We were speaking about addiction there, and one listener taking me to task for seeing addicts as criminals, I suppose, instead of victims. But listen around to say, hi, Fran. I don't think the addicts are so innocent. My daughter was a drug addict. She gave it up with a lot of struggle and help, and that was about 5 years ago. To this day, she is still approached and offered drugs on the streets of Clonmel. Hence, she only goes to town when she really has to. Giving the vote to 16-year-olds is absolutely madness, and they don't know their arse from their elbow. This is one of our listeners, and that seems to be the general thinking. From some of our listeners this morning, Deirdre was on to say, if we only view the people shooting up in Clonmel as victims, then we forget about the damage these people can do to the community when they need money to buy the drugs. As we know, violence and robbery are common where addicted individuals are concerned when they need a hit desperately. The Gardaí should be focusing on arresting the layers of suppliers that are well known to the community and to the Gardaí as well. It's something we will be getting back to, we promise.
Legal discussion on Tip Today is brought to you in association with Lynch Solicitors Clonmel, on the web at lynchsolicitors.ie and at divorceineireland.com.
John Lynch is with me in studio. Good morning to you,
Morning,
John.
Fran. How are you?
It's an interesting topic, that, isn't it? You know, whether do you view somebody as a victim or do you view them as a criminal if they're doing something that is maybe beyond their control a little bit, you know?
Yeah, well, I suppose it's like everything else. You learn as you go on that there's no black and white, there's no straight answer to anything. And yes, there are victims, but I mean, you would like to hope that with a little, that if you come at it from different angles, if you know what I mean, and you deal with it on the basis of education, cutting off the supply, dealing with supply issues, dealing with education issues, dealing with intervention issues. There's not any one answer to any one of these issues, if you know what I mean. And I suppose the longer you look at it, the more you realise that, and it's like what people often talk about law, that law's an ass, and that they think law is black and white, whereas in fact there's a huge amount of grey in it. And the same I would always think when you're dealing with these kind of issues, that if you could deal with it on the basis that you're not going to get one answer, that there's multiple answers, there's multiple layers, And if you look at anybody who suffers from addiction, you always, in my head, I always think that you're dealing with kind of two almost schizophrenic split personality. You've got the addict, which is one personality, and they bear no resemblance sometimes to their other personality, who might be your child, your cousin, your friend, or whatever. That's
a very interesting thing.
But it's hard.
Yeah.
It's hard to, it's very hard to keep that in your mind, when you're. Because we kind of get into a blame game, and we get very unforgiving about people who suffer from addictions, and we think that, and I mean, I was listening to your speaker there talking about, cold turkey versus whatever and how you do it.
Yeah.
There's many, many different ways to deal with it, and the same with the legal system and the same with the penal system that we have. I mean, when I studied jurisprudence years and years and years ago, they were talking about the penal code because it's always a very interesting one to study, how should you approach criminality within the system, should it be penal in the sense that you lock them up, throw away the key? Should it be that you try and educate them and get to them and try and change the way, whatever,
rehabilitate them?
Rehabilitation, etc. And so, after a long debate about it, I remember you kind of come back to the idea that it's a combination of all those factors, and that there isn't any one element to it, that you have to look at all the elements, and not everything is, square peg, round hole. Not everything is going to fit into one solution.
Yeah, it's interesting because that I'm not sure if you saw that video doing the rounds of one guy helping another guy to to shoot up. And I had to say, I found it very sad to see, because they are individual stories. And, you know, if you went back on somebody's history, and I don't know what you'd find.
Correct. And the problem with that is that everybody who considers that to be the wrong approach to take, or the wrong view to look at it, you know, not every case is going to fall into that category. You know, it's a societal issue that we've had for a long, long time, and we get really concerned about it because it seems to be an awful lot more prevalent. Funny, I had a visitor in over the weekend from Switzerland, and we were standing at the main guard looking up the street, and I was trying to do a history lesson in Clonmel, and I felt very, very poor, I have to say. The best I could say was that the main guard was an old Palatine court, because she was the judge.
Right.
She was the judge in Switzerland. And I said it was an old Palatine court, and then I was explaining the main guard, the West Gate, and the significance of that. But while we were there were three... I don't know were they addicts, but they were. Yeah, I think they are. I think you would see them around the town, and they were making a lot of noise. They were having a row, and I said to her, I said, unfortunately, that's one of the things that have become more noticeable in Clonmel than heretofore, and I use that very technical legal term, heretofore. But anyway, she said, "Really, you've only got 3?" And I thought, that's a very interesting observation. She's from Zurich in Switzerland, and she says, you've only got 3, which is interesting because...
Well, she would be used to something...
Much, at a much higher level.
Okay.
You know, which again, you know...
Yeah.
You'd say to yourself...
Interesting perspective on it.
Interesting observation. No?
You're going to talk to us today about a subject I'm hugely, and every broadcaster I know will be hugely interested in this, the idea of defamation.
Yes.
John. What is it, first of all? What is it?
How do you define it?
Yeah.
Well, it's defined, the definition of it is that it's a defamatory statement is one which is published by any means of a statement concerning a person that tends to injure that person's reputation in the eyes of reasonable members of society. So bottom line, it's somebody publishing, as in putting out there, a statement which the content of which is such that it injures somebody's reputation in the eyes of reasonable members of society. So they're all the elements and attributes of what it is.
And has that term taken over from the idea of slander, for example?
Libel and slander it has.
Right. Okay.
Yeah, that's the 2009 definition under the Defamation Act 2009. So it's taken over from what you would have studied in your earlier days, libel, defamation, one being written and one being oral. It's now a kind of an omnibus phrase that covers all of those things. What actually... I find it really interesting because in the modern age now, where online is so prevalent and people are now listening to podcasts now rather than the telly and whatever,
Yes.
So you have a whole load of different forums where defamation could become relevant. And what caught my attention was the 2 cases caught my attention. One was Stillorgan Gas Heating and Plumbing Limited versus Manning. That's the name of the case, but that's not obviously what it's about. But I have the case in front of me, and I better just make sure that I don't get the facts of it wrong. But what happened here was that, surprisingly enough, Stillorgan Gas Heating and Plumbing is a plumbing company, and I'll give it to you off the top of my head insofar as I can remember the details of it. But anyway, the person, Mr. Manning, 2 sisters owned a place in Dublin, and there's a problem with the heat pump or with the plumbing system or whatever, but there's a problem with the pump. And he calls in Stillorgan Gas Heating and Plumbing, and when he calls them in, they give him a price. He pays a deposit. At the end of the job, anyway, they give another price. He gets very infuriated with it all. They go off and come back and remove all the hardware that they put in there. He calls the guards. Then he goes online and he does a review. Now, we all know about these reviews.
Yeah.
And he goes online to do a review. He does multiple reviews. He does 4 reviews in all, is what the court actually decided that he did. But he did a review, and the review fairly defamatory insofar as it was decided to be defamatory. So let's just park that just for a second. So he did this review, and
very critical of them.
Very critical of them, right? Sets out the facts, and he calls them rogues and all this kind of stuff, right? And he gets blocked. He gets blocked. So what does he do? He does another review, and the other review he does in his wife's name because he's blocked. So he uses his wife's name to do it. And we talk about.
Oh, sorry, is he blocked by the social media
by
platform?
social media
okay,
platform?
Not the company.
Correct.
Okay,
yes. Yeah, correct. And he then gets a letter from the solicitor for the company, and he goes on to do a further review. So now he did all this over a period of days rather than weeks or months, if you know what I mean. And there weren't a lot of reviews there, but there was 4 of them, and they were fairly critical of the company. Now, the other interesting backstory to it was that when the company issued the proceedings, took the case to court, he ignored it. He didn't do anything. So when you don't do anything to court proceedings, what happens is that the person who's taken the case against you will go into, I'll use the phrase, will go into court, but they'll apply to the court and say, so-and-so hasn't replied to my case. I want to get you to make a determination. The court comes back and goes, okay, if they haven't responded to you, we will put it in for assessment. So in other words, liability and whether there's a right or wrong to your case won't be an issue. So you've proven liability, but we're now going to assess how much you're going to get by way of compensation. So he actually didn't even defend it from that point of view. So it went into court then for the judge in the High Court to decide how much was the company going to get.
Without Mr. Manning still?
Without Mr. Manning still up to that point.
Okay.
Mr. Manning turns up in court defending himself. And as in he had no counsel, solicitor, no barrister, whatever. So he comes in to defend this High Court case. Obviously the poor old devil was seriously stressed as a result of the fact that we're now looking at a High Court case with a jury scenario, and somebody somewhere must have told him this isn't something you should be ignoring. He came into court, and the other backstory was that he was separating from his wife at the time, which didn't help either.
Yeah.
So you can imagine what it was like from his point of view, faced with a slam dunk in terms of he couldn't argue that he didn't defame the person because he had failed to deal with the case, if you know what I mean. So now he was looking at how much was he going to get hit for in terms of compensation, and the thing to remember about defamation is that defamation, you don't have to prove that you have any actual loss. So if you look at this particular scenario, although it was, funnily enough, when I say funnily enough, it was interestingly enough dealt with in the case insofar as when they set out their case, they argued that there was a loss of income as a result of these defamatory statements or these reviews. They argued that there was a loss, and the person went in and he set out that between this month and that month and whatever, and there was an actual loss. So he was arguing that there was an actual loss. You don't actually have to prove loss in a defamation case. You don't have to prove financial loss. So in other words,
it could be reputational, is that
reputational,
it? Yeah,
precisely.
Okay.
I can see your fair knowledge of this, friend. But yeah, it's reputation. It's reputational damage we're talking about, not pounds, shillings and pence damage. And the pounds, shillings and pence come in when you're going to get compensated. So went into court dealing with how much am I going to have to pay here. Judge hears the case, goes through all the statements, and goes looks at the background to all of this. And the reason that the judge would look at the background, obviously, is to see is there any defence available to this particular individual, or are there any mitigating factors that they should take into account? And then, having looked at all that, then decide what's the level of compensation. Now, I'll sidestep just for a second, insofar as one of the issues that you would certainly be aware of as a broadcaster over the years is the level of damages that was awarded in these cases and the unpredictability of it. Like, you could get an award that could be 10,000 and then following day it could be 100,000, yes, and you couldn't really figure out what is the difference between them all. And that was to a certain extent addressed by the Supreme Court, which is the highest court in the land from a legal point of view, and they addressed it in the sense that they bracketed they used the term, they bracketed the award categories. So they tried to do what they did in personal injuries there quite recently, where they tried to categorise the various injuries and put a figure beside each one.
Yes.
So the Supreme Court actually, in the case that we're talking about, all of the High Court judgments kind of go back to that categorisation, and the lowest category is 0 to 40,000, and then it goes up incrementally after that. So let's stay at the 0 to 40,000 and say that that's the lowest category, but still 0 to 40,000. Now, in this particular case, the judge decided it fell into that category, and he based that decision, that reasoning, on the fact that it was only over a number of days rather than over any longer period of time. He gave the man some credit for turning up eventually in court. He gave him a little bit of credit for the circumstances surrounding the reason, that he put it in his wife's name. He kind of sidestepped. He's kind of said that the marriage was in difficulty and etc. So, not that I'm wondering how that would have probably put it in a little bit more difficulty. You would have imagined, but what he then did after that then was he had to put a number on it. So I haven't looked at it. Would you like to guess what number he put at it? I'd
say 10.
Yeah, 40.
Wow.
He awarded 40,000 in damages. And
wow.
Yeah, and the main reason on it was, and the interesting thing about it was, I think the logic of it is because of the medium that you're talking about. In other words, media. It was up on Trustpilot, which is a platform that you use.
You would go to check somebody else.
The word, the kind of name says it all, Trustpilot.
Yes.
So that was very influential, I think, in his mind. The whole concept of internet, the whole concept of 4 days on social media could be equivalent to a lot more on other mediums, on the basis of the number of people that are now accessing it and the speed with which you can move it on to other people. But an interesting now.
It's very interesting. And was there any account taken of the quality of the work? I have to be careful now in my wording of this. Of the quality of the work done, and because he had issues with the deal that he did with this company, did that play any part in it at all?
It didn't so far. I'll tell you what.
Did you tell me they looked for more money at the end of the process? Was that it?
They looked, yeah. They basically, in other words, don't forget now that the whole issue of that was redundant because he didn't enter an appearance to it.
Okay, so that played into this as well.
That didn't help him.
Okay.
I mean, if he had gone, and interestingly enough, if he'd gone in and justified why he had made the comments, but he accepted that he was over the top. I mean, if you're to read some of what he actually wrote on it, I mean, he even took issue. Like, the poor devil was obviously in a bad place because even when he got the solicitor's letter, like, one of the elements of defamation that they introduced was basically the whole idea of apology, and they introduced that in the 2009 Act, and they kind of made it statute. They created it by statute, by common law. It was always the case that if you got in and apologised fast and said, look, I'm really sorry about this, and you acknowledged the fact, it's somewhat similar to what you get in criminal cases. You'll often hear judges saying, well, I'm not going to give him 10 years, I'll give him 6 because, and I'm not being flippant, I am probably being flippant when I said that, but because he accepted that he was guilty and he expressed remorse, exactly.
Sort of stuff, yeah.
But I mean, he said a lot of the things that he said were fairly, he was over the top, and he went into all the details, and he basically, please don't let them near your home. I should have read the other reviews. These are rogue builders, etc. So he went much further than just setting out the fact, I'm very unhappy with this. And interestingly, the judge did kind of comment during the case that there are things that in reviews you are entitled to say. Otherwise, what would be the point in a review?
Yeah.
So as you say, you can say, so-and-so did so-and-so, etc. And I mean, the thing to remember is that one of the most common... just as another point to make here, by the way, not only is he faced with 40,000, but he's also faced with high court costs.
I was going to ask you about the costs.
Oh, yeah. Because...
And their costs as well?
He wouldn't have any costs because he represented himself, but he'd have their costs.
Yes.
Senior counsel, junior counsel, solicitor, whatever. I mean, you could probably add another...
10 grand, I suppose.
More? Oh, much more. It's high court case, defamation, probably add another 40 on top of that.
What?
Yeah. So, like...
Wow.
And this is what I've kind of said to you a few times about social media. Now, one of the things that you've always got to remember, and I know that all down the years when people come into me on defamation cases, and we've had a few, there's always 2 factors that you kind of have to talk about before you start. And they're always the same. One of them is fairly common to litigation anyway, and is the other party a mark? Will I recover against them? I mean, getting an award of 40,000 plus costs against somebody who has no money is of no value to you, if you know what I mean.
Right.
So Mark is one of them.
This is a cautionary tale, I think, John, for anybody out there using social media.
Correct.
Because I see the most scurrilous things said on social media. And I often wonder, are you for real? No,
correct. And I would agree with you, insofar as I think sometimes people don't realise it, the implications of it, and the wide scale publicity that there, and the very little, the mitigation that you're talking about. I mean, what are the defences? The only defences that you have open to you is that it was true. Now, as you say,
you have to prove that.
You must prove it.
Yeah.
Honest opinion, you must prove it. Honest opinion is what used to be fair comment. But honest opinion, I mean, you've got to back it up. You can't just say, well, I really believed this. I believed it's subjective. You have to prove it with objective evidence. Privilege is the other one, which is an age-old one that's there. And privilege, an offer to make amends, I would caution anybody to be aware of the fact that an offer to make amends is one of the most powerful defences that are available to you, insofar as if you defame somebody and suddenly go, oh my God, what am I after doing? That I was going to say the Saturday night when you have a couple of drinks and you're on the way home and you say something that you obviously, when you wake up, you say, how in the name of God did I ever say that? And it's defamatory of somebody. The offer to make amends should be immediate. And if you make an offer to make amends, that almost is available as a full mitigation defence to you. It's either mitigatory or gives you a full clean sheet if you get in there fast.
Yeah, but the danger there is if you do that, it's an admission of guilt, is it not?
But you see, Fran, that's always the question that's often raised. Do I admit it or do I not? I'm of the opinion that you're better off putting your hand up as fast as you can if you have made a mistake, be it criminal, civil or otherwise, because if you go down the road of, well, look, what I'm going to do here is, if I admit here now, I could be in serious trouble. Now, the reality of it is that the serious trouble you're going to be in if you don't admit it is going to be significantly more in defamation. Now, the other thing I would say before we go off that is, I mean, you've got fair and reasonable publication, but that's kind of more to do with journalism and your area as such. But the other point that I would kind of say to people as well is that there is a time limit on defamation. You know, there is a 1 year.
Oh, it's 1 year, is it?
It's 1 year, yeah.
All right.
So there's a 1 year limit to when somebody can take defamation.
And when you mentioned privilege earlier on, I mean, I would see privilege as what our representatives would have in the Dáil, which is underprivileged. They can basically say what they want, I suppose, without fear of. But when you speak about privilege, there's
two types. There's absolute and there's qualified privilege. So qualified privilege would be a solicitor-client relationship, for example, an employer and employee relationship. There are certain scenarios where, by virtue of the relationship, there's a privilege there, which, as long as there isn't any malafides or bad faith, if you're
yes.
So, like the one that you would often think of as is a reference. You know, an employer gives a reference and the employee isn't happy and they sue him in defamation and saying, now, okay, obviously you've got the truth argument to it, but there's the privilege argument to it as well. But the solicitor-client came up recently, if you might remember, in our case out the road on the land argument between Mr. O'Regan and Coolmore, where there was a consultation with a retired solicitor. Do you remember that? No,
I don't.
There was a case. We're talking about the Magner judgment,
yes.
And John Magner consulted a solicitor, a former solicitor. Well, I was going to say former solicitor. He probably still is a solicitor, but he wasn't practicing.
Yes.
And the argument that was made in the High Court was there's certain communications between them that the other side looked for, and they were denied on the basis of privilege. And this is the privilege we're talking about, solicitor-client privilege. Okay. And the High Court said, no. He's, first of all, he doesn't have a practicing cert for all. Second of all, he's not working as a solicitor, and this is not qualified privilege.
It's all very, very interesting.
But you're right. The ultimate, absolute caution here is it is not a free-for-all on the internet.
And quickly, can I ask you, because many people on the internet are on the various social media platforms, they're anonymous because they put up some sort of a fake name or something like that.
Correct.
What if they defame somebody? Can that be chased back in some sort of way?
Well, that's a really, really interesting point, because one of the reforms that they're looking to put in place is exactly that: identification issues, finding out who made the defamatory statement, and obliging platforms to release the information and to do everything possible to release the information. And one of the areas of delay on being able to take a defamatory action is that you couldn't identify who the person was until a certain time. So if you've got a year to run, Mr. Unidentified could hide for a year, but hiding is no good if you don't know who they are.
Fascinating. There's some breaking news that I'm sure you'll be interested in as well, John. A judge has ruled that the school teacher Enoch Burke should be sent to prison for a fourth time for contempt of court orders requiring him to stay away from Wilson's Hospital School. Now, in a judgment delivered today, Mr. Justice Brian Cregan excoriated Mr. Burke indeed for his behaviour at the school and in the courtroom, which he described as a strategy of verbal abuse and bullying. So that saga goes on and on. Good to see you as always, John. Thanks very much indeed.
Thank you, Fran.
We'll take a break. Back with more in a moment.
Tip FM's Tip Today.
With Slattery's Garage Puckon. Now is the time to pick up your next van. From the award-winning Peugeot Partner van to the Expert and the load-lugging Boxer van. We have big vans, high roof vans, long wheelbase vans. You'll find them all at Slattery's Garage Puckon. See slatterysgarage.ie.